It was September 17, 1998, in Houston, Texas, when John Lawrence and Tyrone Garner decided they wanted to get it on in the heat of a late summer night. As their consensual activities commenced, a neighbor reported a weapons disturbance nearby. The police barged into the wrong apartment, and instead of politely leaving Lawrence and Garner to continue in the fun, they arrested the couple and threw them in jail overnight. The two men challenged the charges, represented by Lambda Legal, a national organization that focuses on queer rights, education, and public policy, on the grounds that it violated their right to privacy and equal protection under the law, since the Texas statute only made it illegal for same-sex couples. The court denied their motion, so they pleaded no contest, and the case was brought before the Texas Court of Appeals. At first, the court ruled in their favor. They thought it was an obvious example of sex discrimination. But after the decision was already issued by a panel of judges, the entire Court of Appeals rethought their decision and convicted the two men again. They justified their decision by referencing the Supreme Court decision Bowers v. Hardwick, in which the Supreme Court found that gay sex wasn't protected by the Constitution, and therefore states could outlaw it, and on the principle that the state could treat queers differently because they did not follow God's chosen good, grand, fine old Texas set of morals. Lambda Legal then appealed to the Supreme Court, where the ACLU urged them to take the case. There, before the justices of the Supreme Court, Paul M. Smith argued the case for the couple and asked the counsel 3 questions. 1. Do the criminal convictions of John Lawrence and Tyrone Garner under the Texas homosexual conduct law, which criminalizes sexual intimacy by same-sex couples, but not identical behavior by different-sex couples, violate the 14th Amendment guarantee of equal protection of laws? 2. Do their criminal convictions for adult consensual sexual intimacy in the home violate their vital interest in the liberty and privacy protected by the Due Process Clause of the 14th Amendment? 3. Should Bowers v. Hardwick be overruled? The judges deliberated for a month, and on March 26, 2003, Justice Anthony M. Kennedy delivered the opinion. Their right to liberty under the Due Process Clause gives them the full right to engage in their conduct without intervention of the government, wrote Justice Kennedy. The Texas statute furthers no legitimate state interest which can justify its intrusion into the personal and private life of the individual. The court ruled it 6-3, and gay sex was liberated.